My name is Chuma Chinyo, and I am your family lawyer. I was called to the Nigerian bar in 1988, and I have over 35 years' experience in family law practice. I've helped countless families navigate Nigeria's complex legal terrain, and I am desirous of bringing this knowledge and expertise to you free of any charges. It's a new day, and I'm glad to be here. In today's episode of Your Family Lawyer, we're going to be tackling the sensitive but very important topic, divorce and separation in traditional marriages under native law and custom. We'll explore how customary courts handle disputes in traditional marriages, and we'll tell you a story of a real-life divorce case. Then we'll unbundle the legal implications of spousal rights in times of divorce. By the end of this episode, you will have a clearer understanding of how traditional marriages and separations are addressed within Nigeria's diverse legal landscape. Let's dig deep into it. Divorce in traditional marriages is governed by customary laws, which vary significantly across Nigeria's ethnic groups and nationalities. Unlike statutory marriages, which are dissolved through formal court proceedings under the Matrimonial Causes Act, traditional marriages often rely on community-based dispute resolution mechanisms. There is now, however, a fundamental saving grace. All such divorce processes and mechanisms must not only be fair, but must be seen to be fair and just. The inimitable yardstick is that the procedures and the rules of enforcement for all of these mechanisms must not be in breach of equity, natural justice, and good conscience. Let's break it down a little bit. There are key aspects of divorce in traditional marriages which cut across most of Nigeria. There is the family mediation. When a quarrel assumes strong dimensions within a family, usually one of the spouses or both would have recourse to the extended family, and then they will sit down. There's what we call discussions, settlements. Each person will say what his or her grievance is, and then the family elders will attempt to reconcile the couple. And when they cannot, they will help them to agree on the terms of separation. Even in customary marriages, there are also grounds for divorce. You just don't wake up and say, I don't want to marry anymore. Usually you would have to give a reason why you can no longer continue with the marriage you agreed to earlier on. And these grounds include infidelity by either of the spouses. It could be by the man philandering, or by the woman straying a little bit into the forest. And there is desertion or abandonment. That is to say, one party to the marriage, just japa, leave town or goes abroad and then leaves the spouse there uncared for. There is the one that we all chuckle when it's talked about, failure to fulfill marital obligations. This could be the known ones, such as financial support, failing to give feeding money, as we call it, housekeeping money, or provide for your wife, for instance. It's a ground for her to go back to her family and say, look, I am suffering. Or the one that she may not even be able to talk about. She will ask him what the problem is, and he will say, ask her what the problem is. That is the failure or refusal to conjugate, in simple language, the inability or the refusal to have sex within the marriage. And there is the omnibus ground of incompatibility. We quarrel too often, we don't agree to anything, and we just don't get along anymore. These ones are difficult to work out in traditional settings because saying to your father that you no longer want to marry your husband because you're just not able to watch football when he's watching football is a difficult thing to swallow. When the marriage collapses eventually, let me put it differently. If the marriage collapses eventually, and then the pieces cannot be put together, usually the bride is expected to return the dowry to the family of the husband. This way, you can say the marriage is now dissolved. It's a symbol, a way to show that the marriage can no longer work. It's been put to an end. Unlike statutory divorces, which require evidence and formal procedures, divorce in traditional marriages is often rooted in cultural and social expectations. That is to say, when there is need for a divorce, what goes on is usually behind the scenes discussions between families to persuade their children to give it another try. But when it doesn't work, then the marriage must come to an end. For example, in some Nigerian cultures, the inability to bear children can be a ground for divorce. But how do you go to customary court to say, I can't marry my wife anymore because she's not able to bear children? Usually, this is something that is muted within the family, and then the wife is pressured to leave. Not the best, if you ask me, but it does happen. And then when elders meet, usually a meeting between both families, and an agreement is reached that the marriage should be dissolved. This paves way for mutual and peaceful dissolution of the marriage. But in some cases, it escalates. Both parties are not able to agree. The elders may not be able to agree, or even if they agree, the couple may not agree. And in such cases, one party heads to the customary court. In the customary court, there are usually a panel of judges or a panel of traditional law experts, or even retirees, persons of repute in the community, constitute these panels in the customary courts, and their decisions are quite weighty. And they can address several aspects of divorce, such as custody of children, return of dowry, and what constitutes financial support, and if that support is needful, and what the quantum should be in each specific case. It is important for me to let you know that customary courts actually prioritize preserving community harmony and adhering to local traditions. Because in most of our communities till date, divorce is still viewed as some form of taboo, and usually divorcees who are women are stigmatized. And so when customary court cases are decided, the judges or the panels usually try to avoid clashes with modern culture, modern laws. And so they infuse legal principles into their decisions to ensure gender equality or constitutional protections where it need be. For instance, while statutory law might enforce personal property division, customary courts may allocate property based on cultural norms, which could disproportionately favor one spouse. It's important to highlight this because what may be considered fair and just in a cultural community, in my community, in Igbo land, may not be so in Yoruba land. I'm aware that in Yoruba land, for instance, when there is a death of a husband and there are more than one wife, his property is shared equally between the wives or according to the number of children each wife has. But in Igbo land, thankfully, often we'll marry only one wife, but in many cases, the wife will have to contend with siblings of the deceased husband. But I'm glad to note that this is becoming rarer and rarer today in Nigeria, and particularly in the place where I come from. It's unimaginable that my siblings would tackle my wife for my estate. Let us talk a little bit about the key elements of a valid customary marriage divorce. The components include the return of the bride price, and it includes involvement of the families. It includes a formal declaration in some customs. In other words, in some places, it will take that community meeting for the marriage to be considered over, and the terms of the dissolution clearly spelled out. In some places, it's just an inner family thing, and an agreement is reached, and then the bride price is returned. Let's not lose sight of the fact that sometimes, even in traditional settings, divorce could become contentious. And when this is so, it will be needful to be sure that there's legal documentation of the dispute and of the resolution. And in this kind of cases, the aggrieved person should usually proceed to the customary court and obtain a formal judgment. The bottom line and the determining yardstick for those who know their rights is that the rules governing traditional divorce must pass the golden test of compliance with equity, with natural justice, and with good conscience. Another way of saying this is that the woman's constitutional rights must not be breached. I'll now tell you a very interesting story of how customs clash with modern day values. And when this happens, the customs would give way. Something happened in Okrika, in the present-day Rivers State, many years back. Under Okrika custom, there is what is called Iya, which is the final level, the final grade of marriage, when the woman can proudly say, I have a husband. But when the Iya ceremony is done, the marriage could be dissolved at will by the husband by simply sending the wife back to her parents. The woman was then free to remarry, and any children of the subsequent marriage belonged to the new husband. Similarly, the wife could call the husband, summon the husband before the chiefs, and have them work out how much should be paid back to him if she intended to divorce him by way of refund of the bride price and all other expenses, including what is called Ikbo and Okuru. But if the husband does not accept the proposed refund, that is the end of it. The woman would not be able to divorce him. The marriage is deemed to be subsisting, and there was nothing the woman could do to get free from it. And any children she had, if she does have children with a new man, those children were regarded as the children of the first husband, and they were constantly treated as bastards. In other words, as children without heritage, without lineage. In this particular case, the father of a woman who was married and whose Iya ceremony had been performed, decided to go to court to ask the customary court to compel the husband of his daughter to accept a refund of the bride price and all other things that he may have done by way of securing her hand in marriage and the conclusion of the Iya ceremony. This woman had in fact left the man for another man years back and had attempted several times to return the bride price, but the man refused. And then the children she had for the other man were considered to be children of the husband she had left and therefore deemed, quote unquote, illegitimate. The customary court agreed with the woman's husband and struck down this obnoxious or reclamative law and custom, which permits a man to divorce his wife but prevents her from being able to leave him. Let me put it differently. This reclamative law and custom, under it, a man can prevent his wife from divorcing him forever and ever until death does them part, though he has a free right to divorce her at his will. This clearly is a custom that is repugnant to natural justice, equity, and good conscience. And so the courts will not allow it to stand. And this particular court did not allow it to stand. Let's see how it played out, actually, in the courtroom.
The sun is setting in Okarika, Rivers State, Nigeria. Chiefs sit in a semicircle under a large tree, surrounded by villagers observing quietly. A young woman is standing by holding the Iya customary bridal wrappers presented to her by her estranged husband during their marriage ceremony. The husband is also present, while her father speaks.
Chiefs, we come before you today to return the dowry. We also wish to return the Ikpo and Okuru cloths presented by her estranged husband. My daughter no longer wishes to remain in this marriage.
Our son, you have heard the request made by your wife's father. Will you accept the return of the cloths and dowry and release her?
Certainly not. She remains my wife. I will not take back the cloths.
Please let me go. I cannot stay in this union. You made life unbearable for me, and you have taken several other wives.
Without the husband's acceptance, the marriage cannot be dissolved under Okarika native law and customs. In the past, customs often trapped individuals in marriages, leaving them without recourse. The father of the young woman decides to challenge this draconian custom at the High Court of Justice, Port Harcourt, in order to free her from the bondage.
My lord, my daughter seeks a divorce from her estranged husband. He did not treat her well in his house, and she was left with no option but to leave. My daughter has moved on, but her husband refused to accept the dowry and ceremonial cloths, which must be returned to him by custom. He has decided to cage her with tradition. She has children for another man, but by our customs and tradition, they are considered children of her estranged husband, and they are treated as bastards until he releases her. I seek a declaration that my daughter has the right to reclaim her freedom. My lord.
The estranged husband defended himself by objecting to the proceedings at the High Court.
This court has no jurisdiction to entertain this matter. My wife and her father ought to have approached the Okirika Customary Court that understands our tradition. These Ikpo and Okuru cloths, which they are attempting to force on me, should be returned to them.
Court.
After reviewing the evidence, this is my judgment. The Okirika native law and custom whereby the defendant can prevent his wife from divorcing him forever, though he has a free right to divorce her at will, is a custom repugnant to natural justice, equity, and good conscience, and as such will not be enforced by this court. The declaration that the bride price or part thereof and the ikpo and okuru cloths shall be returned to the plaintiff is refused.
Daughter and father walk out of the courthouse relieved and all smiles, greeted by supportive friends and family. Today, modern laws ensure fairness and protect the rights of individuals to dissolve unions that no longer serve their well-being, unlike before, when culture and traditions held sway.
Wisdom is a primary thing when it comes to these customary law practices, because by understanding certain principles, individuals can ensure that their customary marriages are properly done, and that if the need, God forbid, actually arises for a dissolution of the marriage, that it is done in a manner that is both culturally respectful to the parties and legally binding in a way that is acceptable to equity, natural justice, good conscience, and to our Constitution. As regards spousal rights, divorce in traditional marriages actually do have very unique legal implications, and they include the issues of right to property. It is true that customary law often does not recognize joint property ownership, and this, in most cases, leaves one spouse, the woman, without a claim to marital assets when the marriage ends, either by way of divorce or by death of her husband. This is not acceptable. This should not continue. And I'm certain that many states, and I'm aware that in Rivers State a couple of years back, a law was passed which removed completely, legalized the practice of preventing women from inheritance of landed property. And then the issue of child custody. This is usually not contentious in customary courts, maybe because it leaves the woman with a burden. Decisions typically are guided by cultural norms, which align with the need to have younger children remain with their mother. But I'm aware that in many cases too, the man would lay claim to the male children, even if they are young, and say, my son cannot go with my former wife. But education is a good thing and is helping us to moderate some of these behaviors. We've talked often about the return of dowry. It's a critical component of divorce under native law and custom. But let's be clear, how much is this dowry we're talking about? In places where dowry can be as low as 200 naira, 500 naira, it's not a problem. But in some parts of Igbo land where huge sums of money are collected from the groom, this could put financial strain on the wife if she needs to return it to the husband's family. Now let's talk about maintenance. This is not always enforced in many customary practices, but in quite a number of them, the need for the husband to continue to support the wife, particularly when there are young children left in her custody, is enforced. This is important to talk about because when a couple gets divorced, the children are not divorced. The children remain the children of the husband. And in many cases, the husband has the means and should be compelled, if he has more money than the wife, to make sure that he contributes to her being able to take care of the children, pay their school fees, provide accommodation for them, and make sure that they grow up to be what you intended them to be at the time you got married. I'll return back to the issue of documentation of traditional marriages because it is one of the key things that complicate issues when it comes to divorce, and even when it comes to determining whether the marriage itself was properly done. This is because the courts rely heavily on oral testimonies and recollection of elders. But you know that when stories are told over time, the original story is usually significantly different from the end story. And so there is a need, in my view, for codification of our traditional marriage practices across the landscape of Nigeria. And this is achievable. It's also needful, in my opinion, to begin to elevate or continue to deliberately, intentionally elevate our customary practices and to be sure that issues such as gender equality and abuse are prevented or minimized as much as is possible when marriages are customary. And also to ensure that we continue to intervene in ways that protect our children who are products of these marriages. Now, let me conclude with this. Divorce in traditional marriages reflect the deep cultural and communal ties within Nigerian society. While customary courts strive to resolve disputes in line with native laws, the outcomes can often collide with modern legal principles. And so if you are navigating a divorce under native law and custom, it is crucial to understand your rights and obligations under both customary law and statutory law. Trust me, consulting a lawyer who is familiar with these intersections can be of help to you to enable you secure fair outcomes for yourself and for your spouse. This will be all for today's edition of Your Family Lawyer. Until next week, when we continue to look into what constitutes marriage and how they affect our everyday lives. Please be informed, be empowered, and be good to your family. My name is Chu Machini, and I am your family lawyer.